Welcome to this recording of the Jurisprudence webinar on understanding EPFX professional use guidelines in the United States. This recording has been made on August 22nd, 2008. How did the subject of legalities regarding the EPFX even begin? Well, quantum biofeedback and the EPFX began gaining favorable coverage on local news broadcasts, newspapers, and magazines. People began sharing their amazing experiences with this modality publicly. The industry was growing quickly as more and more people purchased units for themselves or to use professionally in their various practices. Along with that growth came even more attention placed on the industry as a whole, and occasional statements made about what the device was able to do or amazing results that people had achieved with it, which they associated with device usage, were made. These comments were communicated in ways that seemed, to some, as being outside the scope of its original registration, which therefore turned those communications or statements into a legal matter. Along with that came the unfortunate reporting conducted by the Seattle Times, as well as other news reports that pointed out isolated claims being made. These reports, unfortunately, characterized the entire industry unfavorably, and many would argue unfairly and disproportionately. Following that trend, another TV newscast in Texas did a story on the EPFX that seemed designed to show both positive and negative opinions about the EPFX, possibly as an attempt at fair reporting. They attempted to find people who would make negative statements about the EPFX, and apparently could only find one person to do so, who had never even been attached to the device or obtained a session. They found many people, however, who attested to the positive experiences they had with the device. The presentation they made arguably also presented the EPFX in a positive light, but they failed to post a follow-up interview with the inventor, Bill Nelson, explaining the scientific validity behind the device. Why? We can't say for sure. We can only speculate. Perhaps it's the nature of TV programming itself. One of the tenets of the dramatic arts is to examine conflict, competition, and win-lose outcomes, such as in competitive sports, which garners large audiences who, in turn, are exposed to advertising, such as for pharmaceuticals. Pharmaceutical companies pay TV stations for advertising time in the United States. This is illegal in some other countries. Perhaps there just weren't enough people willing to state anything negative about the device, eliminating the dramatic conflict, thereby making it yesterday's news. However, it may be because it turned out to be a more complicated story, one that they backed out of when they realized that there were conflicting stories coming from within their own industry, and the chance of truly fair reporting was becoming challenging. Because these reports seemed contrary to the perceived truth of how quantum biofeedback users experienced it as a modality, many people suspected hidden agendas operating behind these reports, based in either personal vendettas or as inspired by other competing industries. However, the scrutiny has resulted in a closer examination of communication about the device, one that has caused users to become less casual and more specific in terms of claims. These reports and the efforts of one particularly aggressive reporter placed legal pressure on the FDA to examine these claims because they can, in part, regulate claims made about devices. The FDA investigated and then cited certain claims as inappropriate in terms of how the device is registered, and therefore took action. Their action was to place an import alert on the device until they were satisfied that the limits of the claims being made about the device fell within the scope of its clearance. So what is an FDA import alert status, and is this an FDA ban of the device? An import alert is not a ban on the device itself. People who own and use the EPFX continue to be entitled to do so. It doesn't hurt anybody, and there is insignificant risk associated with the EPFX. It poses no danger to the public in and of itself. However, the FDA considers inappropriate claims as a different form of a danger to the public, and that's what we need to remain aware of. So at the date of this writing and recording, the FDA has not removed the import alert status from their website for the EPFX, but they are nearing what we expect to be final negotiations with the manufacturer, Eclosion, regarding correcting claims and adhering to the tenets of EPFX clearance. This is called a CAP, which stands for Corrective Action Plan. To date, the corrections have been to stop stating or claiming the following. Electrodermal screening. This should be stated as electrodermal response, which is biofeedback, GSR, or galvanic skin response, not screening. Screening infers diagnosis, which biofeedback does not do. They also wanted the manufacturer to stop stating evoked potential biofeedback. Evoked potential neurofeedback devices are different than the EPFX, and they have a small risk of seizure. Therefore, this language is an association that we should avoid for not only the sake of clarity, but also because there's insignificant risk associated with the EPFX, and that is a positive thing. Reading the subtle energy fields. They asked the manufacturer to stop using the word reading because reading anything beyond biofeedback reactions infers diagnostic capabilities, and biofeedback reactions are not considered diagnostic. Also, reading the emotional, physical, and mental levels for the same reason as above. Reading infers diagnostic capacities. Biofeedback measures the strength of reactions. Therefore, it doesn't read any of these items. It only detects the client's reactions to them, such as to matrix trivector signatures and other portions of the program. Therefore, these claims have stopped because they were not entirely accurate, and we should therefore remember not to use these terms because they've been deemed by the FDA as outside the scope of the EPFX clearance, and please be sure that they do not remain in any of your printed materials, either on the web or in your brochures. So why are claims a legal issue? Well, for several reasons, but mainly, number one, claims can be a marketing tool designed to help a product or service sell in exchange for money. Therefore, they're potentially advertising and can fall under FTC regulations. The FTC will follow the advice of the FDA regarding medical equipment. The FDA regulates what a manufacturer or seller can say about the scope of devices in advertising. The EPFX is cleared as biofeedback for stress reduction, electrodermal response, muscle reeducation, and relaxation training. So that would be EDR or GSR biofeedback and EMG biofeedback. It's also cleared for trivector calculations, and the original EPFX matrix of trivector signatures contained a mere 2,000 items. References to virtual were also in the original clearance. However, EEG was removed from the original description, but certain battery-operated devices have since been dropped from the list of devices requiring registration with the FDA and are available over the counter or OTC because they are safe and have a long history of being safe. However, the EPFX has a very important document attached to it called a 510K. Which is a document that states its substantial equivalence to another device, and it outlines its applications. Approximately 5 years ago, it was decided in a court case that a product or service with a 510K could make claims outside of its clearance and 510K if and only if there was acceptable peer-reviewed research that provided evidence of those claims.